morning is in re B.T.B. And we'll begin with counsel's appearances.
I'm here to try to guardian ad litem for the minor children.
Welcome.
Marty, one of the George for the natural mother.
Welcome to you.
Well, I'll take them also, I think George will be the father.
Drove to the United States.
Kirsten, on behalf of the President, that's not
Thank you. Welcome to our report. Okay, I understand the amicus parties here were granted 5 minutes of time. Is that correct? And how do you wish to proceed in order?
Well, I intended to take 13 minutes, but the council might want to take 2 or 5 minutes to reply.
Okay. Let's start.
Chief Justice, Justices of the Supreme Court, may it please the court, Martha Pierce, attorney guardian ad litem. This court has the opportunity to determine whether the best interest provision in 506(3) should mirror what is in B.T.B. paragraph 55, or should mirror what is in this court's opinion in Reg WA 2002 Utah 127 paragraph 31. B.T.B. says that the best interest consideration is an element to be proved by clear and convincing evidence in order to protect the fundamental liberty interests of the parent. It argues for extended reunification, a relative placement to be a defense determination, and I can't remember what else. But Reg WA says that the parent's fundamental liberty interests are protected by the procedural protections in the Child Welfare Code, that once a court determines by clear and convincing evidence that there are grounds, then 506(3) is a mandate. That's what NRAWA calls it, is a mandate to the juvenile court to provide the child with the best interest disposition. Now, whatever strictly necessary means, we know it doesn't, the meaning, the legislature did not intend that it should undermine the provisions of ASFA, which is an acronym for the Adoption and Safe Families Act. The reason we know that is that in the Child Welfare Code, there are 51 mentions to federal law. And the federal law they're talking about is ASFA. And if you want to know the provisions of ASFA, it is virtually the inverse of what is in paragraph 55 of B.T.B. ASFA creates a hierarchy of permanency options. It requires extra steps for the division to go through, or extra findings for the court to make if it wants to make a lesser permanent alternative. ASFA provides for time-limited reunification services, and in the case of the present case, which is abandonment, it says there is no requirement for services, and that is 6 times in the Utah Code, which makes sense because what kind of services can you provide to a parent who has shown disinterest? What kind of services can you provide to give inside interest in a parent? And any kind of services you would give to an abandoning parent would necessarily be damaging to a child who has had his heart broken time after time because he buys into the empty promises of a parent. So reintroduction therapy necessarily requires the children to, again, open their hearts and start to believe what they really, truly want to believe.
Sorry.
Where, there you are.
It's over, yeah, over here. Does section 506, does the clear and convincing evidence standard apply to the facts underlying the best interest analysis?
I don't believe it does. And here's why.
How can you, so help me, just look at the actual statutory language and help me understand how that position can be right.
Well, it is correct that the petitioner has to prove the facts by clear and convincing evidence, and to the extent those facts also support best interest. And I would agree with you that the facts that support grounds always support best interest. But
I did not say that.
Okay.
All right.
Okay.
And I asked if the facts in the matter of the termination proceeding, in which there are the elements right now, are you have to establish the grounds for termination and you have to establish what's in the best interest of the child, correct?
Right.
All right. It seems to me that subsection 3 requires that those be established by clear, both of those facts or sets of facts be established by clear and convincing evidence. I'm asking you if there's a statutory argument, one based on construction of the text of the statute, that is not the case.
I think, yes, I can make that argument, and that is this, that the governing standard are the grounds. And the best interest is a dispositional consideration. And so when you talk about dispositional consideration, it's not a burden of proof, it's a burden of persuasion. And the reason, first of all, it's a consideration because the word says consider. Second, when you look at the pleading statute, which is 505, it requires the petitioner to plead one of the grounds under 507. It doesn't require you to plead best interest because that's your prayer for relief. And then also, every time in this Child Welfare Code, you see a reference to the paramount consideration of the child's health, safety, and welfare, or the child's best interest.
The determination of what is or isn't in the best interest of the child is dependent on the facts. Fair?
Correct.
And those facts have to be established in the trial court's mind by a certain quantum of evidence, right?
Correct.
And you're suggesting that the quantum of evidence for establishing those facts is different than the quantum of evidence for establishing the grounds for termination.
It ends up being the same because the same facts that support grounds also support best interest.
May not.
Actually, I need to push back on the state's brief because they say that sometimes the evidence for grounds may overlap the evidence for best interest, but I suggest that any evidence of grounds always implicates the child's best interest. Because evidence that goes to fitness is not fitness to operate heavy machinery, fitness to parent, and not fitness to parent any child, fitness to parent this child.
I get that, but there may be additional facts outside those that are relevant to termination that a party wants to proceed and present to the court.
Right.
Those need to be presented, the quantum of evidence related to those facts also clear and convincing?
Well, I suggest that because it's dispositional, then it's more an issue of persuasion and not a burden of production.
I don't understand that. It's still based, you're still producing facts.
You are.
And so, and under what standard must those facts be established in the trial court's mind?
I don't think it needs to rise. It generally will rise to clear and convincing. I don't think it needs to, and here's why. Because Santosky is the case that said that to protect a parent's fundamental liberty interest, the facts to support grounds have to go to the level of clear and convincing evidence. Once you establish grounds, you have rebutted the parental presumption. So the constitutional rights of the parent after your district are no longer in play. So there's no constitutional requirement that those facts be presented at that level of proof. And frankly, that's not an issue in the present case, so we're talking theoretically. But because it's a dispositional directive, rather than an element to be proved, a governing element, as Justice Oaks would say in Ray J.P., I don't think that requirement, that constitutional requirement is there.
Can I ask you a little bit more about this? I think that's an interesting point that you're raising. I don't think that the Court of Appeals opinion necessarily contradicts this, and here's why. Even if the second prong, the child's best interest, is its own element that has to be proven, I thought your argument that this is now about the child's best interest.
Precisely.
It's not about the parents' rights anymore.
They're no longer.
Once we move to that second step, including the way the Court of Appeals framed it, what we are asking is in the child's best interest, and we're no longer concerned about how important the parents' rights are. It's the child's best interest.
Exactly.
And that's the second question.
Exactly.
And I agree with you that it would be rare that one of the grounds for termination does not also implicate the child's best interest. There may be some additional information.
Right.
But that second question is only about the child.
Exactly. And when we say, and it's only about the child, and then under ASPA, there's a certain preference for the more permanent alternative. So the opinion asks, what can we deal with a lesser permanent alternative? And ASPA always asks, well, why not more permanent alternative? So let me talk about strictly necessary. So I already said that it cannot undermine ASPA. So what I think to understand strictly necessary, it's important to look at House Bill 161. And House Bill 161 has a number of provisions that essentially tell the Court of Appeals, the juvenile court, and the state to do their job and respect parental constitutional rights. For instance, House Bill 161 included a provision, which is now 78A4201, that tells the Court of Appeals to provide appropriate appellate review, something I submit they have been doing since 1987. It also tells the state to provide sufficient evidence to support their petitions. It also tells the juvenile court to provide a fundamentally fair process. So much of 161 is just reminders to respect constitutional rights. So I suggest that strictly necessary is part of that, and to the extent the strictly necessary clause refers back to 503, I think you can say that. I think because of its position in 507, it can't modify best interest, because best interest is in 506. And because of its position in 507, it's removed from the list of grounds, so it can't modify grounds. So I suggest that it should be read of a piece with those reminders to respect.
Can you help me understand that? So how would a juvenile court harmonize strictly necessary with ASA and the timelines in the code?
Well, I think the sponsor on the floor said it has something to do with strict scrutiny, which again, that's the appellate scrutiny given to when a statute intrudes into fundamental liberty interest. Or you could say it is saying that protecting a parent's constitutional rights is strictly necessary. But I can't give any other reading that would harmonize it with ASPA than what I just said.
So you think it modifies, can you clarify that one more time? What do you think it modifies, the strictly necessary?
I think it refers back to all those provisions in 503 that are drawn from Santosky that essentially that say things like the state should provide sufficient evidence, the juvenile court should provide a fundamentally fair process, that essentially remind parties that the parents have constitutional rights. I think it goes to that.
Another way to read it is that it's going to follows off almost automatically line of cases from the Court of Appeals. I think you're asking us to endorse that line of cases. We've never previously done so, and I'm not sure that I can understand why we should. Can you speak to that?
Okay. Almost automatically was not a rule or a doctrine, it was an observation in a concurrence in Re JD. And what they were, and I think it might be better to say it's highly unlikely, something like that, such as what Justice Peterson just said.
But it wasn't just in a concurrence. It got picked up in a further line of majority opinions.
It got picked up, but if you look at where it's been picked up, you never see an almost automatically analysis. It's a much, each time the Court of Appeals or the juvenile court, when they refer to that, then they go back to really analyzing it.
So I mean, that way of thinking about it would be sort of, well, it's not really doing any work. It doesn't really advance the ball at all. It just seems like at best it's confusing. At worst, it's reframing or kind of reordering the order of operations under the statute. I think that's what the Court of Appeals opinion in this case says, and that's kind of the way I'm inclined to think of it, which is why I'm giving you a chance to help me see what I'm missing.
There's two valuable pieces underlined almost automatically. And I agree that there's a better way to word it. But one of the valuable pieces of almost automatically was in the concurrence. The concurrence was pushing back against the majority who said we have this hurdle, we have this barrier. And the concurrence was saying it's not so much of a hurdle because evidence of grounds always implicates best interest. I forget what the second way, but he was pushing back against that. Oh, and he was pushing it back against when the judge, the juvenile judge said, well, your evidence for your best interest evidence is pretty scarce here. And so I think the concurrence was pushing back saying, no, if you have heard 3 hours or 3 days of grounds evidence, you have also heard best interest evidence. And then the concurrence reframes the grounds evidence through a best interest lens. So the two valuable pieces are that the evidence for grounds always implicates best interest, and that the juvenile court has a duty to consider the grounds evidence through a best interest lens.
Can I ask it in terms of some of the facts of this specific case?
Okay.
Help me understand how it could follow almost automatically, where you have a father who is not going to be replaced by an adopted father, and whose ground for terminating his parental interest isn't that he abused his children. It's that he's been pretty, I don't want to minimize this, but it's different from, some sort of physical or sexual abuse. It's that he hasn't been involved in their lives and he hasn't shown up for parent time and that sort of thing. So how could it follow? I mean, I get that it might well be in the children's best interest in some cases, that kind of a showing of a basis for terminating parental rights would also be enough to suggest that it's in their best interest that his parental rights be terminated. But I don't see how it could follow automatically that a father in that circumstance who's not going to be replaced by an adopted father, that it's always in the children's best interest to cut off his rights.
And I'm not suggesting that the court just says, well, if you have one, you have the other. I'm saying that the court says if you have one, it is likely that you have the other, but you still need to do the analysis. And in the present case, adoption has a special place in Utah law. It's always been a ground for termination. It's mentioned several times in In re JP. And in the case following In re JP, In re Castillo, I think it is, there's a footnote that says adoption is different than other grounds, because other grounds, sometimes the parent can't help their condition, but abandonment is a willful act. Now, when you're looking at, when there's no father to replace this person, he still has, you have to look at the legal structure of parenthood. So if the mother wants to move, she needs to notify him. If there's a medical, there's all sorts of provisions in the code where she needs to notify him. He still has all sorts of access to the court to demand this and to demand that. So he has broken the trust relationship of parenthood, but he still wants the rights and duties of parenthood.
I think I see that point, but it kind of sounds like you're sort of conceding, though, that it doesn't follow almost automatically from that kind of determination of a ground for termination, that it's in the child's best interest.
I can't see how it would be in the child's best interest to have a person like that maintain that type of control over the child.
Let me try to reframe my question more specifically. Do you think it always follows almost automatically from every ground for termination, that it's in the child's best interest to have parental rights terminated?
I don't think it's automatic, but in my experience, it is a very rare case, and the rare cases rarely come to court. We have seen cases where there's an older child who feels responsible for their parents' feelings and they're not ready for adoption, and those cases just never go to court. So it is highly unlikely that you're going to get a case that gets as far as the trial court and that gets as far as the Court of Appeals where it's not in the child's best interest. But it's not an automatic analysis. The court needs to carefully consider what this child needs. But as Justice Peterson said, the child needs to be in the center of that analysis. But to say it's automatic, I think, demeans the work of the Court of Appeals and the work of our juvenile court judges.
Can I, before you sit down, run a reading of Strictly Necessary past you and just get your reaction to it? So, I think one way you can read 503 is the legislature sets out a number of policies, a number of thoughts about things that the juvenile court needs to consider. And it culminates in subsection 13. And subsection 13 starts, whenever possible, family life should be strengthened and preserved. And there's a but, and it says, but if a parent is found by reason of conduct or condition to be unfit or incompetent, and he goes on to say the court shall then consider the welfare and best interest of the child of paramount importance. Is there a reading that says that 507 should be read in light of 13? And so when we talk about strictly necessary, what we're talking about is the language the legislature uses, that means whenever possible is what strictly necessary means, because we're trying to harmonize these two provisions. Do you see any concerns with that reading?
Yeah, and that also harmonizes with least restrictive, because when the state wants to intrude into a family's life, they have to use the least restrictive means available. And so I think strictly necessary goes to that. It's the least restrictive means. then if services are appropriate, then they use that. So I think it fits into that concept.
So are you aware, did the strictly necessary language come into the code at the same time as 503? And those were
503 has always been there, but it was a lot shorter. And so NRWA talks about 503, but 2012, all the Santosky language came in 2012.
And so this subsection 13 and the wherever possible language?
That was there before.
That was there before?
Yeah, and you can see that in NRWA. And subsection 13 pretty much mirrors what you have in 506.3. So that they're pretty much saying, here's how, and it makes sense. You want to strengthen family life, but when it's not possible, when you find grounds, when you rebut the parental presumption, then the juvenile court's duty mandate is to consider the child's best interest.
I just wanted to follow up on Justice Lee's question and give you sort of my take on the two prongs,
Okay.
the grounds and the best interest, and see if there's anything that you push back on with this. So for me, I think that the observation about automatically follows. If we just limit that to sort of pushing back on the notion that, well, we haven't heard any best interest evidence because it may not have been specifically labeled that.
Yes.
That we acknowledge usually grounds evidence may be relevant to both. It probably will be
Always
relevant.
relevant. Always relevant. Always. I mean, you can't think of an exception.
Right. It's hard to think of a time when it wouldn't be. But you still have to analyze both separately.
Absolutely.
Grounds, and you still have to
And it's a
look
different
at-
lens. It's the same evidence, a different lens.
It's at a different lens. So you're still looking at both of them separately. So if you haven't heard the words best interest, it doesn't mean, well, we don't have any evidence on best interest.
Exactly.
But maybe there's additional evidence
Sure.
about best interest that wasn't necessarily a ground, and that should be considered on child's best interest. But
Absolutely, yeah.
so you don't have any pushback to that type of thing.
No, I could not have said it better myself. So, if there's any more questions, thank you for your time.
I'll note for the parties that, as you've seen, we've allocated time to you, but should we still be asking questions, you may exceed that allocated time.
Thank you very much. Chief Justice, Justices of the Supreme Court, may it please the Court, Martin Woomer of St. George, representing the National Mother.
Would you agree with the argument made in the amicus brief that there is evidence that maintaining a relationship with a biological parent long-term is valuable for the child? Not in each instance, but it's valuable.
I agree with that concept. I don't agree with
Would you agree that the legislature, as the policy-making body, has the right to put its thumb on the scale and say, in doing a best interest analysis, we really think that that is valuable, and we want courts to heavily weigh that in the process?
Yes.
And is 503 a way in which the legislature has expressed that policy decision?
I think 503 was the exact way that the legislature was trying to put that in terms of we have all of these things.
So with that as background, let me propose to you an interpretation of the strictly necessary language and see what you think. That in keeping with the provisions of Section 503, including those provisions that recognize the fundamental liberty interests of parents concerning their children, a trial court must strictly scrutinize whether termination is in the best interest of the child.
Yes. Yes. I think that fits with what Ms. Pierce was just saying. That two-pronged test is there. Once those grounds are clearly there, the lens changes to that best interest.
But it is, the lens truly changes, but it's a little bit like how we might, when a fundamental liberty interest is at stake, how carefully do we evaluate the best interest, or whatever we're maybe evaluating, against that fundamental liberty interest? And it seems to me that the legislature is putting its thumb on the scale. And it's suggesting that there are significant advantages to preserving the relationship as it stands, not terminating that relationship. So it's starting like this. And before, you know, when you do the best interest analysis, you have to make sure, trial court, that you're overcoming that. And the facts that overcome it have to have been established by clear and convincing evidence, trial court.
And I agree with that, Justice, and I would say it in this regard. When those facts are established on one, parent, mom, or dad, those facts are established by clear and convincing evidence, they have failed. They've met the abandonment, they've met the neglect, whichever point that is.
But that may not, depending on the evidence, it may not be enough to shift the balance, is what I'm suggesting to you. And a court has to take a careful look at whether other evidence of what is in the best interest of the child, even though termination may have been established, is outweighed. And in doing that, it really is an invitation for the court to strictly scrutinize that inquiry.
And I would suggest this in that regard, that there's also a shift that after point one is made, we look at it from the child's viewpoint. Their rights, their interests, that scrutiny comes from their viewpoint. Dad's or mom's, of course, rights were met when we found by clear and convincing evidence abandonment, neglect, or any of the other points. And so the shift, now let's look at the lens, what does the child need? The parents' rights were met under prong one.
I don't disagree with any of that. To say that one of those rights, one of those interest analysis points is that preserving the relationship with the biological parents is in and of itself valuable and kind of weighs in favor of maintaining that relationship. And whatever the evidence is, it's got to be enough to overcome that type of evidence. And there may be additional evidence.
And there may be. And I agree with what regarding the life and portrait. All of this evidence over in prong one is going to overlap over here. There may be additional points.
Can you talk about the evidence related to that? There are references to testimony of a psychologist or a psychiatrist about the effect it had on the children. Am I remembering this correctly?
Yes.
And I realize that, you know, we want to respect the privacy of people, but was there evidence that, even considering that generally it is a good thing to preserve, you know, a parent's relationship with the child as a general matter, that in this case, the unreliable nature of the father's interest in the children's had overcome that? Or what was the evidence on that point?
My recollection of that was the trauma that was created to the children by dad here, dad not here. Dad may be here, dad may not be here. Was creating emotional trauma to the children to the point where the professional was saying it's better not to have this person even associated with these children because it is damaging them too much. To bop in, bop out, maybe be there, maybe not be there.
And why is it when there's not another adoptive parent stepping in as the father, there's no stepfather here, step in and adopt, why is it beneficial to the children to have this father no longer have rights to be consulted on, you know, their medical care, their education, have rights to parent time? How does that help stabilize these children's reality?
I think part of it, what I just said, as long as that parent has a tie, that child has additional trauma in their life. Because they will know that asked about me. Dad did this, dad did that. There's another element that I think is.
So you're really advocating to cut it out entirely of the child's life then? No visitation, to bar all contact with them, and you think that is consonant with the best interest of the child in a case where dad has been incarcerated and out of jail? That's
Incarceration and out of jail, not necessarily. I can think of a situation where if dad went to jail, but wrote to his child every week for 52 weeks and maintained that contact, it would be different.
There's a suggestion in the briefing that termination doesn't mean that that individual no longer have contact with that child, no longer be involved with the child. But what you're really saying is that shouldn't be the norm. The norm should be you're out.
I think the norm should be that's the possibility. In situations where, I can see situations where if dad comes back and he's rehabilitated, and in this situation where mom has maintained contact with grandparents, his parents, it may lend itself to that, but it doesn't require it.
It seems like that's beyond a court order, though, that
It is.
really, the court is just being asked whether this parent should still have the legal ability, the legal right to demand certain things.
Yes.
Consultation from the other parent, time with the children, whether that parent follows through on it or not. So whether there is actual contact or a relationship, the court doesn't really have control over that. I think what the guardian ad litem was arguing is it just allows the fit parent to set boundaries and not be legally required to consult with the parent who's not fulfilling his obligations.
And I think there's one other point that I want to make that fits your question, and that's if mom, in my case, untimely dies. If this parent's, if dad's rights are not terminated, he can step in and demand his rights as a custodial parent and be as strange as even this parent testified to in the trial court. I recognize my neighbor's son doesn't even know him. That was his testimony. And so when we have a situation like this, one of the reasons, additional reasons for termination is to look at that potential. If mom has an accident, if mom passes, we throw children to a stranger instead of to a family core that they are thriving in. And I think that's a very important aspect of the termination statute when we get to that best interest. As framed as strictly necessary, we look at those future possibilities. And so, yes, Justice, when you say time in jail, I don't always agree that that's going to be the telltale sign. Although the legislature has said, if it's more than a year, we presume that it's abandoned. But in that situation, with dad's writing, they're FaceTiming, they have tablets in jail now that they can do those type of things. In a particular situation, that may change my opinion. I'm sure that I've exceeded my time. Are there further questions?
Thank you.
And thank you all.
Good morning. My name is Rob Latham. I represent the natural father down below. Question for you. I see the clock ticking down over to 15, so I reserved 5, so they're ahead of me when I heard the time allocations. Mr. Chief Justice Duran, when I heard that last name, I probably want to ask you outside of this forum whether we grew up in the same Olympus Cove neighborhood together, but maybe we'll save that for another time. But it's good to be with you. I think I've never appeared before any of you until this morning.
I think we can take judicial notice of the fact that the chief's 30 years older than you are, so, oh, sorry.
I'm going to turn 51 next week.
Yes, 32.
Oh, wow. Okay. That's good to know. Thank you. So I'm going to start with this panel the way I started with the Court of Appeals, which is just a request that we take the legislature seriously. In fact, I just want to recognize that Laura Christensen, who's the author of House Bill 161 from 2012, is here. He's probably trying to hold himself in his seat when he hears questions about what the legislative intent he had for this legislation. And I get that discerning legislative intent is a tricky business. When Justice Levy, your question about how that House Bill 161 really, I think, reordered the analysis of how we're dealing with these termination petitions in juvenile court, I think it did do that. So even if we're looking at an opinion like in Rita WA from 2002, we're just in a different place now with the passage of House Bill 161. And that's why I think when I cross-petition, I'm very appreciative of what the Court of Appeals did in its B.T.B decision in disavowing the almost automatically line of cases. But I think because that was such a heavy lift in clearing away that underbrush, what I think they came up short in doing is not really taking that strictly necessary language seriously and the way it invoked the protections of 503 and that whole process. And I can tell you just the reality is in the juvenile court I normally practice in when I'm usually representing parents responding to Division of Child and Family Services petitions to terminate parental rights. Prior to B.T.B., we were operating under that almost automatically reality of you got grounds, you got best interest, and kind of you're done at that point. So I think it was in recognition of that reality that was happening in the juvenile courts that Utah legislature passed House Bill 161, parents.
Is there anything in the legislative history that makes reference to the almost automatically line of cases?
I'm not aware of it.
I looked and didn't see it, but I mean, time-wise, it kind of makes sense that it may have been a reaction to that.
You're right. When you look at it from 2012, and I want to say there was an opinion that, or an appellate opinion that came down a year or two before that I think was somewhat of a trigger. We could probably ask someone who really knows the question who's here, but I know we're not set up to do that. So I don't know. But, as I said in our brief, it seems like when the way that House Bill 161 kind of reordered the analysis, we used to just, look at grounds, can we terminate, then best interest, should we terminate. Strictly necessary, I think, looks at that termination question from kind of a different perspective. Do we have to terminate? Do we need to terminate? And that's why...
Whenever possible, we should not terminate.
Right, and especially when we have all of these other, I think what prior decisions have recognized are statutorily preferred dispositions. Why not a kinship placement with a family member, even if you got to go,
But that's contrary to the position you took in your briefs, isn't it? I mean, didn't the way you worded in your brief say you would start with that, should we not, or whenever possible question, and not wait till the end, let the court look at the evidence, and use that whenever possible, that strictly necessary language, to choose between options and say, look, is there an option that promotes the child's best interest equally well that allows the parental rights to remain intact?
In my mind, procedurally, that's how you ought to start the process.
Which way? I'm sorry. The way in your brief, the way you seem to be talking about it now.
Start with strictly necessary first, you mean?
Uh-huh.
Yeah. No, I think I will agree there's overlap in I think all these questions. I think the implications of what dispositional options you might have, you're going to somehow look at best interest in the grounds, the situation. I think that informs it. So I think there's some overlap. But
isn't it more than just inform it? I mean, I was confused by the suggestion that you make in the brief that you start with strictly necessary, because I don't know how you can analyze strict necessity without taking into account strictly necessary to what. And it seems to me that the most obvious answer to that is that it goes to the best interest of the children.
Well, and that's why I think my cross petition, I disagree with what the Court of Appeals did in rolling strictly necessary into the best interest analysis, because I fear I'm seeing that already in decisions interpreting B.T.B. is that it's just starting to get swallowed into that best interest black hole. And I think if it's set aside, then...
My question is, how can you ask strict necessity in the abstract? I mean, maybe you want to say it's not just best interest, maybe you want to say it should go to grounds. I mean, maybe it's just a reminder that judges ought to be really careful and wary and not do this lightly. To me, that's kind of what it's getting at. But I just don't understand how you could sort of say, step one is it strictly necessary? That's just not a question that can be asked in the abstract. You see what I'm asking?
Well, let's see if I get your point. As I kind of said below, I was asking myself this question, strictly necessary, okay, strictly necessary to do what? And the answer I've come up with, just given the whole statutory scheme, was strictly necessary to effectuate an adoption, to facilitate an adoption. That's the only reason you would terminate.
But can you show, where do you get that in the statute? Because I think Justice Lee's question is precisely the right one. Strictly necessary to what? And so what in the statutory language suggests to you strictly necessary to effectuate an adoption?
Well, we talked about the adoption code, so that talks about determining parental rights to facilitate adoption. So that was actually in Mr. Winward's brief down below where he raised that. So we talked about that in our oral argument down below. And it just seems, when we try to interpret these statutes and as a harmonious, whole, it just seems to me that's the only sense because...
Well, why does that harmonize better to the whenever possible language of subsection 12 of 503? I mean, that subsection 12 seems to be the legislature telling us how after, listing all of these principles that the juvenile court needs to keep in mind, this is how it envisions it working, and that whenever possible, the court's going to keep parental rights intact. So why isn't it strictly necessary to the best interest of the child?
Well, it might be this whenever possible stuff, because I think, we talk about, doors and strictly necessary, we have multiple doors. We have permanent guardianship, we have temporary guardianship, we have kinship placement, then we have termination of parental rights. So whenever possible, have we exhausted all these other doors? And are we looking at termination as a last resort? Which I think this court is short.
Can I ask you about that as a jurisdictional matter? So if you have a proceeding with the state, you may have some resources available, but let's say in a situation like this where it's a private party, the mother seeking determining rights, the only thing the juvenile court, and please correct me if I'm wrong, I may be wrong about this, my understanding is the only thing the juvenile court has before it is that mother's petition to terminate parental rights. Are you arguing for, and the Court of Appeals opinion could be read to sort of be requiring the district court or the juvenile court to sua sponte search for options that are not before the court. Is there a guardianship, a temporary guardianship? Is there a kinship placement, even though the court's not being asked about guardianship? Is that jurisdictionally appropriate for us to require the court to seek out other options that are not before it? The only question is presented here by the mother, I want a termination, yes or no?
Yeah, that's a great question, Justice Peterson. I think we've started to refer that as the binary question. Is it yes or no to this termination petition? But I can tell you that the way it's kind of played out for a couple of these post-B.T.B cases is the judge I practice in front of has denied the termination petition but ordered something else, like a permanent guardianship. And why that's happened is, I think we have language in code, I want to say it's 7886 1103, talking about modification, who has standing to modify certain things, and it disables the parents who have termination or permanent guardianship from coming back to court and doing that. Now we have the Restoration of Parental Rights Act, which is a different thing, that's driven from the child, or the guardian, not from the terminated parent, or when there's a guardianship. I did want to just touch on, since we talked about psychologists, psychiatrists, if you look to the record, I did bring them with me. It was a licensed clinical social worker, and if this goes back, I know that's one of the issues we're going to raise is, was this person even qualified really to be testifying?
Can I ask one more question on this though? So are you arguing that we should require a court to go beyond what's presented to the court? So if some of the evidence is, okay, I've had drug problems or I've had these problems, but I have a sister or a grandma who can step in and help while I'm in rehab. Of course, the court should consider that. But what if the parties did not present any of that evidence? Is the court supposed to sua sponte request evidence about possible kinship placement, who else is available, who might be a guardian? Are we placing requirements on the court to go beyond the arguments and evidence presented by the parties and the specific petition that's been filed to the court? Is that what you're seeking?
That's a great question, and as to whether it's proper to raise that sua sponte, I would hope that a judge would, because of the fundamental, parental-child relationship that's involved there. I would hope that that judge exhausts all other, dispositional options before saying, okay, we run out of options, and the termination one is the only one that we're left with that makes sense. So I would hope they would, but I guess the tricky question is, if a judge didn't do that, is that, I forget our term, is it, error, what kind of error? I want to say there's some language in, there's so much going on in these kind of cases where that question came up, this binary question, what authority does the court have to, instead of granting or denying a termination petition, doing something different? And I want to say we did find some statutory basis for that. I could do a supplemental brief perhaps if you want us to do that.
Is it your position though that at the outset of what you see as the sort of strictly necessary sort of first step inquiry, that if there isn't some alternative placement, that a father, like in your client's position, that father's rights could never be terminated?
I think you have to show why the termination, what makes that termination strictly necessary. And so the adoption one's easy because you've got to clear the way to facilitate the adoption.
Okay, so in my hypothetical, there's no adoption, there's no possible kinship placement, there's nothing else. In your view, that's the end of the matter. The father's rights can never be terminated.
And unless there's something else going on, I just don't see on those facts.
I mean, what about the fact pattern that's, or the hypothetical that's raised by the Court of Appeals, which unfortunately is not so much of a hypothetical in a lot of cases? What if it's sexual or physical abuse?
And I think the courts are kind of trying to get the parameters. So CCW, I know, is a Court of Appeals decision that kind of says, go back and revisit that, because we see a lot of domestic violence, and we want to see if that impacts the children. But there's, and then I want to say it's GJC, where the juvenile court said, yeah, there was a lot of this stuff going on between the parents, but we don't really know that it was negatively impacting the children. So I think
I'm sorry, go ahead.
Oh, sure. So I think those, where we're at now, there's going to be a more searching inquiry when we...
Can I just close the loop on this, though, and then let the Chief Justice ask his question? It sounds to me like, though, the way you just answered that question, you're no longer really saying that this is a step one, that strictly necessary is a step one that takes into account, is there an adoption or some other kind of placement that is possible? You are now conceding that at least sometimes it might fold into the best interest of the court.
Yes, Justice Lee, and the reason I say that is, well, I think it could be a step one, and just, how it's nice when we have these three criteria, and sometimes we say, we don't need to get to the other two because we've really solved this one. So I think if we start with the strictly necessary question first, we can perhaps dispose of a lot of these before getting into the messier questions of grounds best interest. So that's why I think that makes sense. Chief Justice.
Can you envision a circumstance where, even if there is something like a kinship placement alternative, it could be established that psychological trauma, unrelated to abuse, physical or sexual, could make a determination strictly necessary?
And I'd still want to know more. I would want to know, I think the example, and Ms. Kirsch raised this example, the family members are horrified that the parent, the bad acting parent is still in the picture. And what about the children? From the child's perspective, is it strictly necessary? Does it help the child? And does that override, I also do juvenile delinquency stuff as well. We have a lot of kids who don't necessarily like what their parents are doing and vice versa. So, at some point, how much do we defer to the child on that question? And how much, do we defer to that constitutionally protected current parent-child relationship? So I would just want to know more about what is it about terminating parental rights?
That seems to be part of the argument here. That uncertainty, the in and out, is psychologically damaging to the children.
Yeah.
And why is that? Why has the mother failed to establish that?
Well, again,
Where's the evidence falling short?
I'm recalling the social worker in this case talked about therapy sessions with the children, and they would mention my client, the natural father, and they'd get excited about him, and then they'd get anxious about whether he was going to be in their life or not. And I just in hindsight, we're revisiting this case. In hindsight, just given the procedural posture of it, and going, well, was that really enough evidence to terminate someone's parental rights? Because we see that in many kinds of cases where we don't go to that, again, drastic step of terminating parental rights. So I would just want to know more about that psychological abuse. I think if it was targeted toward the child, I think that's a much stronger case than just kind of incidental to a messy divorce.
Seem to be conceding as a general matter, there may be circumstances where you don't need to have any adoption.
Well, it really depends on how this court goes, because if it's rolled into best interest, if strictly necessary is rolled into best interest, then yes. But if strictly necessary gets to be its own prong, then to facilitate an adoption, then I would say no, because you're not facilitating adoption. Now, if it's strictly necessary is its own prong, and it's strictly necessary to terminate because of her psychological trauma, then yeah, I guess I would agree with that. Strictly necessary to really, prevent some kind of abuse that's directed at the child or indirectly impacts the child, because it's so severe, then I would say yes.
But of course, we're just not making it up, right? I mean, we're trying to decide what the legislature said the way it should operate. So I'd just like to get your best argument for the textual evidence that the legislature intended that strictly necessary to be a step one. Where do we find that in the text of the statute?
I think it's just, it's plain language and where you find it, and just kind of where it shows up in the ground. So I think it's 507, and I brought my Scalia and Gardner with me, and I think I cited that in the brief, and just I think just as a matter of statutory interpretation, that's how you read that.
By where it shows up, you mean that in subsection 1,
because it's subsection 1.
introduces the remainder of the section. That's the structural argument.
I mean, that's certainly one argument. Where it's placed, it says, let's look at all the 503 stuff, which unfortunately, as a practical matter, we don't do enough of when considering these petitions in juvenile court. We ought to do that more. So we've got to go through all that 503 analysis, I think, first. And then, if the court finds strictly necessary, even after doing all that 503 analysis, so we're just out of options, the court may terminate parental rights, but then we go to grounds. And then we go to best interests again. I think we visit best interest a couple of times along the way, just especially given this court's precedent and also the statutory scheme, which is good to do. But sometimes when we say, oh, we solved the best interest question over here, sometimes we may say it's best, we found best interest to do this. Maybe it's not necessarily the best interest to terminate. So I think they're separate questions. And again, like this paramount importance from the child's perspective, okay, maybe we have to get the parents out of the picture. Well, from the child's perspective, what makes the most sense? Should we do a permanent guardianship? Or at least there is that tie that remains, or guardianship placement or something like that. So I think we can still come back to those kind of dispositions. And boy, I see I'm at zeros, so I will go sit down.
Thank you.
Chief Justice, may it please the court, Colonel Brulé on behalf of the state. As you know from our brief, we are largely in agreement with the B.T.B decision, with a caveat that we think has been alleviated to a large extent by subsequent decisions, including orders of affirmance from the Court of Appeals.
Joya, may I ask you about a slight modification of the construction of the statute that I proposed earlier? What's wrong with the analysis that says, in keeping with the provisions of Section 503, including those that recognize the fundamental liberty interests of a parent concerning their children, the trial court must determine that termination is strictly necessary to the best interest of the child?
Any problem with that sort of construction? I think that's exactly
That was placed on it by the Court of Appeals.
Yes. Yes, and when I considered Mr. Latham's brief, I came to the same conclusions that were posed by the questions from Justice Lee and Justice Pierce, which is that it is tied to 503, and 503 paragraph 12 does discuss best interest being paramount. So it's all tied together. In 507, the first thing the section says is subject to the protections and requirements
503.
of 503, and if the court finds strictly necessary. So it is harmonized by the Court of Appeals decision. And the way you stated it, it makes perfect sense in terms of the statutory construction.
And I thought Justice Pierce's point about the wherever possible language in 12 seems particularly useful to me. I wonder if you could react to this, but it seems like maybe 503.12 is just sort of cross-referenced in the negative in 507.1 strictly necessary. In other words, if it's possible under the considerations in 503 to preserve existing family life, then you should do so. But if it's not possible, then it's strictly necessary. Aren't those just sort of converses? Obviously?
Exactly. That's exactly how I saw it all harmonized to begin with. So I think the Court of Appeals decision makes complete sense from that standpoint. It's the only interpretation that makes any sense. You can't start with strictly necessary in a vacuum. You can't say it's strictly necessary if you haven't heard evidence. You haven't heard evidence about the parent's conduct or evidence about best interest. And one of the issues that's come up is whether the grounds and the best interest entirely overlap. The GAL says that our brief is inaccurate. The evidence of parents' conduct is relevant to the best interest inquiry, but there's always additional evidence about best interest beyond that. There always is, about what their needs are in their current placement, and what's the long-term view in terms of a variety of factors. So the Court of Appeals agreed in paragraph 22, it may overlap, but it doesn't necessarily always completely overlap. And if it completely overlapped all the time, it would be almost automatically, which is
It can't be. There
what we have.
It seems to me you can put on all kinds of additional evidence as a parent that would go to the best interest of the child that is not related to termination.
Right.
Can you tell me?
Oh,
Please do.
do you agree that the second prong, if we agree that both of them are independent, they're independent considerations, grounds, and the child's best interest, that some of the evidence may overlap and be relevant to both. But on the second one, that the only thing we're asking about, a court should be asking about on the second one, is the child's best interest. On that prong, that's the only question. Do you agree with that? Do you have any pushback on that?
Not at all. I do agree with it. It is exactly what is stated in the statute, has been stated in the case law, and is also part of the ASPA statute that has been discussed here. The child's interests and needs are paramount at a certain point.
And that goes to my question as well. Can you help me understand how you harmonize strictly necessary or whenever possible with the timelines in the statute and with APSA? How do those interact?
Well, and that was our only concern about this decision, is that it is inconsistent with state and federal mandates about timely permanency and not providing services for such a lengthy period of time that the child remains in limbo. And as you know, all this came up because children were languishing in foster care. These cases are different from B.T.B, the cases that we handle that the state's involved with, because, and they're very, I understand you have that same standard, you can't have a moving target, the courts have to know what standard they're applying. But when you have a private petition, there's not a child in foster care who's been abused by parents who doesn't know what's going to happen next or where they're going to be placed. Sometimes they're too young to understand it, but in these private petitions, the children are with a fit parent. That's typically what happens. That's what happened in B.T.B. So these permanency timelines and mandates are a very important consideration for the juvenile court, and I think they have to factor it in to the best interest inquiry as part of the strictly necessary.
Does it speak to whether something is possible or whether something is can't be necessary because it's an option that PACS has taken off the table? I mean, is that the way to look at it? That you have to respect the timelines, therefore it might restrict the range of options that otherwise might be available to the juvenile court?
No, it's not like strict liability. The court should be engaging in a robust best interest inquiry that looks at all the options. And typically children who've been in a placement for a lengthy period of time during the course of this foster care case, we have a lot of evidence about how they fared and how they fared away from their parents and how they're attaching to adults. And we do have relatives coming forward, and the other parts of the statutes, as well as the federal law, require that early on, that those options get explored early on in the case, before you reach the point of termination. Sometimes it's an ongoing inquiry, depending on how the child's doing in the placement.
So even those considerations are already baked in?
They are. So,
Ms. Verdoy, can I
yes.
just ask you, in the Court of Appeals opinion, it encourages looking at other options, the court to look at other options. And I have a couple of questions about that in terms of the petition that's before the court and the question that's actually been put before the court. They may not have a guardianship petition. They may just have, in a private case especially, just a petition for termination. And the parties may not have come forward with additional evidence of temporary options. And I'm not sure how that would work when you do have one parent. This isn't a case where the child has no parents involved and they're in foster care, and so you're looking for a grandparent to take over. If the sister of the father steps forward, does the parent who's the custodial parent, right, then have to now negotiate with the person who's not the child's parent? I'm not quite sure how that works, but I'm wondering if you could just speak to the jurisdiction of the court based on what's actually been put before the court, what petition has been filed, and what are we putting affirmative obligations on the district court or the juvenile court to reach outside the petition that's been filed and to have an obligation to look for evidence that may not have been presented by the parties? How do we balance that? I think some of the language in B.T.B could be read to be requiring that, and I'm just not sure what we should do with that.
Yeah, that's one of our concerns, just in terms of you reach the termination point, and then the court's supposed to now look for other adults who can care for this child. And of course, in the juvenile court scenario, that would not be consistent with the permanency and the long-term best interest in terms of the way the statutes expect these to be handled. But in the district court or in the juvenile court with private cases, that is a difficulty, because the juvenile court maintains ongoing jurisdiction even if the termination petition has been denied. So the juvenile court still has options available to make some decisions and some determinations under its statutory structure.
So in a case like this, what are the options other than termination or not?
Well, unless, as Justice Peterson says, some adult has come forward, a relative or someone else, with a petition for
Would that make
guardianship.
sense in a case like this with one fit parent? They just substitute in? Is that a real option?
It doesn't seem to be a real option.
So are there other options that you can think of?
At the last minute, when the court says, I don't know, I'm not going to terminate, but are there other options? If those haven't already been presented to the court as part of the evidence.
I'm just wondering theoretically, in the case with a fit parent.
Right.
I
I can't imagine how the court would handle that. So we've been heartened to see the subsequent decisions and orders of affirmance after B.T.B that seem to recognize at least the uniqueness of state-involved cases, the permanency timelines, the mandate, not considering less permanent options. That has all seemed to be going well in terms of the Court of Appeals decisions, allowing the juvenile court to factor those things in. So The only other thing I'd just like to say really quickly is that I think the juvenile courts in the state of all cases has been handling this B.T.B analysis already very well for quite some time, doing a robust best interest analysis, treating it as if it needs to be analyzed under a strictly necessary standard. I think any suggestion that now they're starting to, or they didn't used to do it, is not accurate. So, thank you.
Mr. Doherty, can you think of situations where the parent in a private termination, it's not the state, but where one parent is saying, like here, no, I'm not alleging physical abuse, I'm not alleging sexual abuse, but because this other parent is so unreliable, it's psychologically very difficult for these children. I think the guardian ad litem is arguing that, look, a court is not going to order, you don't ever see your father again, you'll never have contact. But it's severing the father's legal rights to demand consultation and parent time and whatever, so that the fit parent can set boundaries and say, okay, we're not doing this anymore. What is your position on that? Can there be appropriate circumstances where the parent's not doing physical damage to the children, but there could be a showing of psychological damage that would make a termination in the child's best interest so they can have stability?
Certainly, there can be a case like that out there. It would probably be fairly rare, but we only see the cases we see in the juvenile court that come up on appeal. Every case is different, and sometimes you see pretty extreme circumstances. If you have a fit parent, the state isn't getting involved, but there may be a lot of psychological damage going on with children. And certainly, psychologists are in the best position to help the court understand.
Thank you.
Okay, thank you.
Chief Justice, Justices, may it please the court. My name is Kirsten Norman, and I'm here on behalf of the Parental Defense Alliance of Utah, and we are a tax-exempt charitable organization that provides support and training to the attorneys who represent parents in Utah juvenile courts. And our membership includes those attorneys who have contracts with their counties to participate in child welfare cases, and it also includes members who simply have an interest in parental right termination with private cases. So we have a rather unique handle on particular challenges in this case and how it impacts private termination, but more importantly, how it impacts the broader and the world that we see it more often in the context of child welfare cases. I think it's unique to note that it's pretty atypical for the DCFS Council and for parents and attorneys to be on the same page on these arguments in these type of cases, but in this case, we're squarely in agreement that the Court of Appeals got the B.T.B analysis correct. And the reason for that is because the B.T.B decision does an excellent job weighing against two incredible sources of harm that comes to children in these cases. The first is obviously the harm that's inflicted upon them by a manifestly unfit parent. But the second source of harm is one that perhaps we're less familiar with in a general way, and that's the scientifically documented lifelong trauma imposed on a child by the permanent severance of their relationship with the parent. And this is the legal severance of that relationship, but what that ends up looking like in actuality when one parent has instigated that action is that, for all practical purposes, the small children don't have the ability to rekindle that relationship until they're after 18 years of age. And the B.T.B decision does a great job of making sure that we're not only examining the unfitness of a parent, which is an incredibly important step in this analysis and should take place first, but we're also looking at a holistic examination of whether termination is still what's best for this child, given that termination is not a faultless or a harmless answer. Termination has negative impacts on children that are well documented. And a lot of those are articulated in our brief when we go to things that any child who experiences termination experiences. And whether it's justified or not, they'll experience that mourning of the relationship they have with their parent, and they will experience ambiguous loss, which is very hard for children to process because physical death is a lot easier for a child to understand.
Do you have pushback on the guardian ad litem's position that if a parent has there are grounds for termination, there are grounds of unfitness, that termination just means they're legal rights are terminated, they will no longer have the legal right to demand parent time and other things that they get through that right. But they could certainly still have a relationship. It just means that the parent, the custodial parent, can be in charge of setting those boundaries. Do you have pushback on that? What's your position on that?
Yes, I do. It would be that the reality of the situation that the parties return to after that kind of decision is that one parent has the parental presumption that they get to make all of the decisions for the child, and that could include cutting off that relationship with those children, and that often happens. We see that very typically with these kind of cases. Also, it's important to remember that the opportunity that delinquent or parents have taken or tried to take with this case language in the past to try to alleviate themselves of the fiscal responsibility they have to their children has been denied. So we're not just cutting off those interactions, we're cutting off the children's right to receive support from that parent, and that's just providing an opportunity for bad acting parents to get out of their responsibilities.
We recognize that, I think what you're saying is that one parent, if the state's not involved, has already made a decision to seek to terminate the other parent's rights. These are not parties that are in harmony.
Correct.
And that it would be the rare case in which that parent would then turn around and say, oh, but of course, come visit your child whenever you want, or let's establish visitation.
Exceptionally rare. And I can't think of one where I've seen something like that happen. These harms are more than surface level that these children experience at the hands of a termination decision. Termination is most appropriately compared to chemotherapy or some sort of medical treatment for a child. It can be necessary to save a child's life or to protect them from great harm, but if we use it and it's not justified, we're inflicting harms on the child that they don't deserve. This is not, the best interest inquiry is not an opportunity for a parent to relitigate what they did wrong. It's an opportunity for the court to take a holistic examination of this existing relationship, this child's relationship with their parent, their relationship with the kin that surround that parent and the community that this child is plugged into, and say, despite these shortcomings, is there something about this that's worth saving, and can we come up with a more creative solution that allows these bonds to stay in place?
How should the court, what responsibility should be placed on the court to affirmatively have a checklist of certain things that the court should look to, especially if maybe the two parties didn't present evidence of that? Should we require courts to look for certain things regardless of what's been presented to the court?
Well, I believe, because from our perspective, the larger world that this decision is going to impact is child welfare cases. In that case, the requirements procedurally are that we've been looking for kinship placements, and we've been looking for alternatives all along the way that are shorter termination that might serve this child and minimize the harm that the child experiences. So in terms of the child welfare cases, I think the likelihood that we get there is very low.
What about though in a private termination where maybe these children have not been in any system, they've not been in foster care, they haven't been before the juvenile courts, and it's just, they have a fit parent, there's not a history like that. What about in those cases?
Well, I think that it's the response, we're looking at, like we've talked about a little bit today, the psychological damage that a child experiences because of a neglectful parent. I think that hopefully in these cases, as part of best interest inquiry, part of that kind of information is presented. It should be considered in context with, well, is that as great as the harm this child would experience if these rights were permanently severed? But it's not, ultimately the decision that the court is being asked is termination appropriate given what we've seen today? It's not saying we therefore are going to craft a solution that invents a relative where we can send this child. It's saying today we haven't met this evidentiary burden that we're required to meet. And that hopefully as that language is understood and read by courts below, we'll realize this is a holistic examination. We have to have an idea of where this child will go, what the impact will be if this relationship is severed, and is there something short that we utilize?
So the Court of Appeals uses the language that a court should consider or explore alternatives to termination. How does that work in a private termination case?
Well, if you look at the decisions that have been issued in the wake of B.T.B, that consideration it's not overly onerous on a court. They've had like one paragraph indication that, well, you know, these proposed situations weren't appropriate. And I think particularly where you can document well with experts that there's psychological harm to a child by continuing the relationship due to severe emotional abuse or neglect, that would speak to that sufficiently that it wouldn't require additional in the creation of relationships that don't previously exist. We're asking what's best for the child. We would never want a court that isn't experienced with the members, the potential caregivers outside of people that are presented to have that duty to create an option that wasn't there.
Thank you, Mr.
Here's Attorney Garden and item. The wherever possible clause has got to be read with section 312.5, 312.4. And I say that because you need to look at the company that abandonment keeps, and abandonment is listed in that. So it talks about the cases where there's sexual abuse, sexual exploitation, abandonment, severe abuse, severe neglect. Neither the division or the court has any duty to make reasonable efforts. So there are certain carve-outs from the wherever possible language, and abandonment is keeping company with all of those other grievous.
And that seems to comport with the way subsection 12 is constructed, because it's wherever possible, it should be preserved. So wherever possible, X.
Yes.
But
Yes.
if you have grounds for for termination, abandonment,
Yes.
then Y, right? So I mean, there's some temporal language in terms of the but-if clause and the then clause in there.
Right. And I just wanted to tell the court that abandonment has a very different place in our law than other forms of unfitness. And the legislature has put it over there for a reason.
So tell me what's wrong with the reading that I've been giving others, and that is in keeping with the provisions of section 503, including those that recognize the fundamental liberty interests of a parent concerning their children. A trial court must determine that termination is strictly necessary to the best interest of the child.
The problem I have with that is strictly necessary means can we make do? Can we make do with something
Yeah, but
less?
it's got to mean something.
I know it does. And so I think strictly necessary goes to least restrictive alternatives and wherever possible. I think that makes sense. But I think to tie it to best interest, then changes best, which is optimum, to least restrictive. And least restrictive is the standard you use prior to the parental presumption being rebutted. After the parental presumption has been rebutted, then you look at optimum, which is why the question isn't, well, will this hurt the child? The question is, what's best for the child?
It's still paramount, but it's asking us to really think about the requirements of section 503, including those incorporating much of what's been talked about here, that there is value in preserving that relationship. That in and of itself is in the best interest of the child, and we shouldn't lose sight of that.
Well, I have two answers to that. One is to the extent that 503 factors go to a parent's constitutional rights, those are no longer in play at that point.
But to the constitutional right, Ms. Pierce, 503 recognizes it is in the best interest of the child to maintain that relationship.
And that language is taken from Santosky, and that language is presuming a fit parent. But to the extent that your question...
I see what you're saying.
Yeah.
Okay.
But to the extent your question is saying, what about when there may be value for the child to have an ongoing relationship? Then it really makes a difference how you frame that. Because if you frame that in terms of the parent's right to visit, then that parent has that right to be intrusive sometimes. But if you frame it in terms of this child has an interest, and who is best to shepherd that interest and take care of that interest on a day-to-day basis, and that's going to be the presumptively fit parent, which under Jones versus Jones, we're going to trust to make those everyday best interest decisions. And to say it's rare that kids don't have an ongoing relationship with their terminated parents, I cited a number of cases where that's the case, and particularly with older kids. That is just the case. A lot of times, a kid gets replaced in therapy where you need to bring the parent in, you can do that. There are times when that's important, but the person that should mediate that should be the fit parent, not the parent that the law presumptively says can no longer act in that child's best interest.
As a general matter, Ms. Pierce, do you agree that there could be certain circumstances harm to the child resulting from severance of the parental relationship.
And we've encountered that, but then generally you never see a termination. We've encountered that where a child, especially an older child, like I said, feels responsible for their parents' feelings, or somehow the symbolic value of adoption and termination, they just don't like that.
So regardless.
And so we have seen that, yes.
Okay, so regardless of where the relative burdens lie, which is an important question, and regardless of the appropriate structure of the analysis, you can envision circumstances where, in considering best interest, the court would weigh potential harm flowing from severance against the harm of a continued relationship.
Yes, and yes, exactly. And somebody mentioned child support, so I want to refer this court to 514, which deals with voluntary relinquishments. But that says that even if the main motive for the parent to relinquish is to get out of their child support obligation, 514 says that the child's interest in permanence and stability can outweigh that. So I think the legislature there tells you how you consider the issue of child support. Oh, yes, so ASPA
I'll
also...
let you conclude quickly.
Okay, one more thing. ASPA says that even if you're placing with a relative, you still have to rule out adoption. So relative placement doesn't rule out termination and adoption. So if there's no other question, I thank you for your attention.
Thank you. Ms. Booth.
So again, Rob Latham for natural father in this matter. Going to the issue of permanency option. So, and this is, I think, where kind of the next challenge will be is why do we have to rule out adoption and somehow we're ignoring all the other permanency options that are out there. And I really direct this court to my reply brief and citation of the Josh B.T.B article. It's long. Skip over his experience with Washington, D.C. stuff. But there's some great information in there just about all these other permanency options that are out there. So if we resolve these cases down below, these division cases, with something other than termination and permanent guardianship was offered, we would be done so much easier and quicker in a lot of these cases if we considered those. But it seems like, too often we're just looking at termination of parental rights as just the default option out of the gate. And so that's why I think, it would be great if this court could, kind of carry on with what the Court of Appeals did in B.T.B. and just said we were looking at termination as a last resort because, we're looking at these other possibilities in that subsection 12 language. So, and I did want to speak to the child support issue because I'm going to have a matter next week where we've got my client who wants to relinquish, the child wants my client to relinquish, the guardian ad litem representing the child wants my client to relinquish, but the parties opposing relinquishment are the other parent who collects child support but is in jail, so I wonder how that works. And then, of course, DCFS opposes that. So, should that relationship be severed when it seems like, why are we keeping the parent in that scenario, but for a paycheck? And, right now, maybe we're saying, okay, well, it's strictly necessary and there's no other person waiting in the wings, and, maybe that's the so-called taxation on being a parent that I've heard some Indians say. Just looking at my notes, there was a comment made about juvenile courts have been mindful about the strictly necessary language, but I think how we got here was I kept seeing that language and that being given short shrift, both at the trial court level and then in appellate opinions. And there was just a recent Court of Appeals decision in Rate HF, which I think the court for just being too conclusory in the strictly necessary analysis. So I think the strictly necessary language is great, and B.T.B is super helpful in that it's going to require trial courts to just really do that analysis and exhaust all those other options before we go to the termination of parental rights route. Because, again, kind of it's a permanency issue, where I think we're going to bump up against the constitutional dimension of this parent-child relationship and saying, well, have you ruled out adoption? Why do we have to do that when there are all these other permanency options out there, people come to, the juvenile court on in and say, we tried the adoption and it's a disruptive adoption. It didn't work out. And so now we're looking for some other resolution. Restoring parental rights, I've seen that as one option, or, something else. This issue was raised about, okay, in this particular case, what happens if the parent, custodial parent dies, and then the other parent's there and suddenly has their rights? What do we do in that case? Well, I would anticipate that family members would learn of this, there would be a shelter hearing, and we would get that child in a safe environment. So I think there's a mechanism in place to address that issue. If my client is not in a place where it is ready to assume those parental duties, there are other mechanisms in place where he can again still preserve that parent-child relationship, that constitutionally protected parent-child relationship. And that way we just protect against what Santosky was concerned about, which is irretrievable loss of family life if we're not careful in this termination question. If there are no other questions or comments, I'll submit it.
Thank you, Mr. Latham, and thank you very much to all counsel. We appreciate your arguments and we'll take this matter under advisement. At this point, we'll take a brief recess. When we return, we'll get a case of UDOT versus Lotus Traeger Company.
Will all present in the courtroom